This is the current federal tax developments for the week of May the 12th, 2025. Current federal tax developments are brought to you by your state society of CPA. And this week, we're looking at a few things that went on during the past week in the area of federal taxes. First, we're going to talk about an IRS determination letter on deductibility of in vitro fertilization and gestational surgery. I'll get that surrogacy cost. Talk about those two. It is a topic that gets covered quite a bit, I guess, we'll say at least reasonably often in various rulings, because there's always this interesting question of what are medical costs in cases like this and what aren't. So we'll talk a little bit about that. We're going to talk about a case where a taxpayer ran into, under a different title, not Internal Revenue Code, but Title 28 of the U.S. Code, Section 2514, because the court decided that they had submitted a fraudulent claim, or fraudulent information to back up their claim for a refund from the IRS, and that basically got their entire case thrown out of court. We're going to sit back and see whether there was something they might be owed. They simply had forfeited the right to challenge this at all. So we'll talk a little bit about that. I'm going to talk about the tax collection suits and the status limitations in United States versus Ragen. So we'll talk a little bit about that, why, how these things gone, why this taxpayer in question, even though he had waited 10 years after assessment, still found that, the IRS could still basically get most things that they were going after, most what they went after. We'll talk about a case where a civilian contractor for the Department of Defense, who was ordered by DOD to relocate, discovers that unfortunately she does not qualify for a moving expense deduction, even though, she believed it applied to those in the military, which it does, but she was not actually active duty in the military. So the fact that she may be military related, she may have been told by the DOD to relocate, doesn't itself get her a deduction here, as she discovered. And finally, we have another case that's going to court now in a different Circuit Court of Appeals than the Third Circuit in the Culp case. So we're going to talk about a case that came up where we're again seeing the question raised about whether, if a deficiency petition is filed late in the tax court, does the taxpayer have the right to be able to argue that they should be able to, present to the tax court, a reasonable, let's say, excuse for why they did it, so that they could get, a basically extended statute. And the problem is we're looking here for equitable relief, and we'll discuss that because clearly the tax court believes the answer is no. So now we're going to have another circuit that appears is going to rule on this issue. So it could be interesting to see where we go. Oral arguments were held this week, so we'll talk about what went on in those oral arguments and where we're going. But let's start here with navigating in vitro, I'll get it right, fertilization and gestational surrogacy costs involving medical expenses. What of those are deductible, one aren't? This was an IRS determination letter, 2025-18023. Interesting that it was a determination letter and not technically, a normal, what we call private letter ruling. They're really pretty much the same, but this one did get published. It came out May 2nd, 2025. Let's talk a little bit about what was going on here. Now, here's the facts. We have two taxpayers, right? Husband and wife. They're a heterosexual married couple. That's pointed out as the facts they had there. Now, taxpayer A had a pre-existing health condition that meant there was a very high risk for her if she went through a full pregnancy. And basically there was not good odds for, in essence, the child coming through as well. So there was all kinds of reasons why it did not make sense for her to carry a child. Now, they engaged the services of a gestational carrier to carry their biological child. So we were going to basically, through in vitro fertilization, we were going to be basically planting, the egg would be planted into this, basically surrogate, and then the surrogate would carry the child to term. And they incurred expenses for the in vitro fertilization procedure using eggs from the taxpayer A and using taxpayer B sperm, and expenses related to gestational surrogacy. And these expenses were incurred over 3 years. Now, they filed joint returns for years 1 and 2. They claimed no deduction on those who were awaiting the IRS determination, and they are waiting to file their 3rd-year return. The question they're asking is, of a whole list of expenses they incurred quite a bit of expenses, which of them, if any, were eligible for a deduction on 213, which, by the way, would also impact which of those expenses could legally be reimbursed from an HSA, or I should say reimbursed without having to pay tax on the income, or from a flexible spending account. So it impacts that too, because 213 essentially controls that. So this has implications beyond simply whether you can claim a deduction for medical expenses. Now, as I said, they requested the determination letter of their unreimbursed expenses for both the in vitro fertilization expenses and the surrogacy's expenses. They want to know, as medical expenses under 213, which of these expenses would qualify. They acknowledged in their request that it's going to be subject to a 7.5% of adjusted gross income threshold as a Schedule A medical deduction. Now, Internal Revenue Code Section 213 is what covers medical expenses. And 213A allows a deduction for any medical expenses paid for medical care of the taxpayer, the spouse, or a dependent when they exceed 7.5% of AGI. Now, big issue always in any tax law is looking, is there a specific definition here of the terms involved, or are we dealing with the general definition, what we normally expect a definition to mean, those terms to mean? When we look for medical care, we do find that in Section 213 D1A that there is a definition of medical care. So for purposes of this section of the code, medical care is amounts paid for the diagnosis, cure, mitigation, treatment, or prevention of disease, or for the purpose of affecting any structure or function of the body. And those last terms are going to be key here, because obviously we don't have a disease here, right? None of this treats a disease. None of this directly treats the underlying condition of taxpayer A, right? These expenses are essentially, though, expenses being incurred, and the question becomes which ones can meet this test. And the key limitation, which is always raised in every one of these rulings we've seen and other related rulings, we have a lot of rulings related to infants and various other things. The deduction is only for medical care of the taxpayer, spouse, or a dependent. This is where it becomes a significant issue, because the problem you run into is when you have these other third parties involved, even though the expense would be one that if whatever we're talking about here was done to one of the taxpayers, would be a deductible medical expense because it would qualify. The fact it's being done to the third party, or is part of the process handling the third party, does tend to get in the way of getting any deduction for those expenses, and this will be no exception. So the IRS went through and applied the definition of medical care under 213 D1A to the various specific procedures. So essentially, for in vitro fertilization procedures, right, expenses for the egg and sperm retrieval procedures, they qualified as medical care because the IRS said both of those affect the structures of your body. Because of that, falling under the affecting any structure or function of the body prong would allow you to claim expenses there, at least some of them. Now, when we looked at the surrogacy expenses, that looks at who received the medical care. And here's the problem. The expenses related to the gestational carrier were not for the medical care of taxpayer A, taxpayer B, or a dependent. That at no stage until the birth of the child is that child potentially a dependent of somebody. So we have to realize that's been consistent here, because that's usually where people try to argue here or try to get into it, is saying, well, the whole point of this is to to arrive at a dependent, right? That's kind of the point of this. That's where we're going. But the problem is they said, no, at the moment, those expenses for that third-party gestational carrier are non-deductible expenses. They are the medical expenses of that party. That party is not paying them. And they are, and you are paying the expenses, couple, but it's not for medical care of anyone for whom you can claim a deduction, right? Basic structure. Now, I suppose you can argue that, well, at least do we kind of get out of the gift tax? Well, yes and no. I think there'll be a contractual arrangement. So this isn't exactly a gift to the other party. So I don't think we have a problem there. They're being compensated. It's just an expense of incurring that. But even though, and it is very expensive, you're not going to get a deduction for this. The law does not allow for it. Now, what in vitro fertilization expenses were incurred, or were, I should say, approved? And the ones they specifically approved were screenings, fertility medication and treatment, and egg and sperm retrieval expenses were all considered to be deductible medical expenses. Remember, in each of those cases, the party receiving the medical care is going to be either taxpayer A or taxpayer B. So, and of course, they're the two on the joint return. So they're fine. Now, again, the condition must exceed 7.5% of adjusted gross income. They must be married filing jointly, and they will file amended or original joint returns to claim these expenses. The IRS said the reason we approved these is that the egg and sperm retrieval expenses affect the body structures of the two taxpayers. So they qualify as deductible medical care under the definition found in 213. Now, basically, gestational surrogacy expenses, that was a complete disallowance. We denied any expenses incurred related to the surrogacy, right? The gestational surrogacy. So that is when we get to that point. They had a long list of things that didn't count that they said was not everything. But what you couldn't take, which we know, which from this ruling is, the IRS says you can't any carrier testing, medications for the carrier, or procedures costs for the carrier. None of those are deductible. The embryo transfer fees, that would be for carrier pain and suffering. Embryo storage related to the carrier insurance, life and disability policies on the carrier, delivery costs for delivery of the baby, legal fees for parentage, and base reimbursements to the carrier. The basis for denial of all of those is these are expenses directly for the identification, compensation, medical care of a gestational carrier. And the related reimbursements are not for the medical care of the taxpayer, spouse, or a dependent. So essentially, because this is usually the theory people have, we're having a child and, for medical reasons, we either can't or be very inadvisable for us to go through, the process of, what we'll call the traditional method of having a child. So we're going to go through this process, and we need a surrogate for this process because it is either medically highly inadvisable or medically impossible, for the mother to carry the baby to term. For that case, what would be the biological mother to do that, which is fine, but it doesn't, it's not going to get you a deduction under current law. The key thing when faced with a case like this is always focus on who is receiving the medical care. Remember, you have got to tie it to a taxpayer, the taxpayer, taxpayer's spouse, or the taxpayer's dependent. It's got to be one of those three. Remember, we don't count the child as a dependent until the child's born, right? Remember, that's a requirement to have a dependent on the form, on Form 1040, if you may recall. So since they don't count until that point, anything that impacts them, and even if they did, we get into this weird concept of, some of those expenses still wouldn't really be affecting the child directly. They'd be affecting the carrier, like, paying the carrier. is not really directly affecting even the embryo in that case. So that would also be a problem. Now, this is a termination letter specific to the taxpayers that requested it. So it cannot be used or cited as precedent. That said, I think you'll find the average agent will consider this very, let's say, helpful. You'll find it helpful and convincing that this will work because obviously the question's been posed to the national office. The national office has come back and said, these items are deductible, assuming the agent's going to try to throw the whole thing out. It does illustrate how the IRS applies the medical care, and it's something to remember, right? This is how you do it. Remember the fact that it's got to be for the taxpayer, spouse, or dependent, and it must be for a disease, which normally requires you to have a formal diagnosis and something recognized generally in the professional literature as being a disease, or for the function of a part of the body, which is a broader definition, can cover other things that are not disease-related. CPAs advising clients are going to have to analyze the detailed facts of the situation. A client's likely to walk in the door and say, well, we had a surrogate, we had to use in vitro fertilization, we had a surrogate, and our total costs were X dollars. It's like, we need to break these down, right? We're going to have to break down the costs and look at each one individually because this is not the first ruling of this sort. You're going to have to check and see, which of the costs are going to be considered allowable and which ones aren't. That'll make a difference. You got to ensure documentation that's also going to be clear, right? You don't want just sort of a general number thrown around. We need to go get the specific documents to back up the medical expenses incurred on behalf of the taxpayers or taxpayers' dependents, and not the ones incurred, and separate those from the ones that are being incurred for the other parties in the arrangement. Next up, we're going to take a look at a U.S. Court of Federal Claims case number 24810. It was filed on April 30th, 2025. And it's going to be the Quinones versus United States case, right? This is a question of how a taxpayer managed to get their entire case, even if they had a refund coming, whole thing got thrown out of court because they were creative. I mean, I got to say, these guys were really creative in this case. Now, we have two pro se plaintiffs. That's probably part of the reason we've got this here. And so Mr. and Mrs. Quinones, my Spanish is horrible on that, sought substantial tax refund of $4,547,247 following the IRS disallowance of their 2021 refund request. You're going to shoot for the sky, I guess, was the idea if you're going to ask for a lot of money. This claim was based on their 2021 federal income tax returns. Now, they reported income of $1,433,860. They had very large wage amounts reported on their attached W-2s, $4.5 million for Mr. Q and $9.4 million for Mrs. Q. They also reported significant federal, Social Security, and Medicare withholdings. As you might guess, that's going to be where the problem comes. And they allege the IRS violated Internal Revenue Code Section 31 for giving wage withholding credits, for not getting full credit for this, and for not, under Section 37, providing them with the requested repayment of their overpayment, right? They're saying they owe us this money, they're required to do it. Now, as you might guess, you need some more facts to figure out what's happening here. Wow, they had that level of return. The first thing you may be thinking, which probably a lot of us would be, is, $14,400,000 of income. Why in the world? And you're asking for over $4.5 million in refund. Why didn't you get legal counsel, to take the case to court? Why are you doing a do-it-yourself project? Well, we'll discover the whole thing's been a do-it-yourself project and not necessarily the best one. There was an enormous difference between reported and actual income and withholdings. Now, for Mr. Quinones, who is from First Systems LLC. It was that's an entity he controls, an S corporation, so an LLC operating as S corporation that he controls. He reported $4.9 million in wages. Remember, in reality, that company only paid him $91,899.98. Now, you might be thinking, well, wait, tax fraud. Why would you grossly overreport your income? How would that lead to tax fraud? There's going to be a ton of tax due. Well, turns out he reported $766,000 of federal withholding. In actuality, he only had $14,200, and then he also reported huge differences for Social Security and Medicare. Now, at trial, he admitted that the $91,899.98 was the actual amount the company had paid him. He didn't dispute that. And his company, which he controls, makes about $8,000 in profit a year. So, okay. Now, for Mrs. Quinones, she was paid by a third party, Vistra Corp. She reported $9.4 million in wages. Now, the W-2 her employer filed with the IRS showed only $175,393.72. She reported $1.4 million federal withholding, and actually it's only $26,433.47, and she had huge differences for Social Security and Medicare. Again, the actual W-2 was accurate, and her Form 1040 numbers in no way remotely resemble her actual W-2. Now, as you might guess, they're going to have severely overwithheld Social Security, right? Severely overwithheld, severe excess withholding. So we're playing with these numbers. Also, they basically fabricated numbers per the court's term. The court called completely fabricated numbers for other items, like nearly $8 million in medical and dental expenses that turns out wasn't anywhere in that range. What is causing all of these numbers to blow up? What's their justification? Because again, they're admitting that the actual cash written from the companies, the actual, gross wages paid, are way lower than what they reported. So how in the world are they justifying this? Well, they did struggle. Now, Mrs. Quinones, she just deferred to her husband. She didn't really have any explanations, except that her husband handled it. And she mentioned that the excess reporting were intangibles that were known only to him that were involved in this. And they involved goodwill, notes, and asset valuations that were not yet cash, existing in cash. Now, Mr. Quinones prepared the return. He created his W-2s via ADP software, which is kind of interesting. That's mentioned in passing by the court. We don't know exactly what he did, but somehow he got them out there. And he testified the inflated numbers included intangibles and notes like going concern value and goodwill. And he claimed that this is justified by Internal Revenue Code Section 197 and also by Regulation 1.197-2, which is a going concern definition. He then takes that into basis for 1012. Now, as you might guess, if you know 197, right, the intangibles from buying businesses, etc., you're like, that has nothing to do with any of this. Well, the court agreed. The court found his results unrecognizably skewed definitions. We don't know. I mean, let's be charitable to him and suggest it made sense to him. Unfortunately, in a pro se taxpayer, sometimes that's what's happened. They've gotten into this, they've gotten into theories, they've read various, let's say books or other articles written by people who don't know what they're doing, right? Or who are in it to charge money to get this to people. You see all kinds of weird ways it gets done. But anyway, he bought into this. And so, of course, he's now created these huge multipliers, which means that, right, if you have all that extra income, it's horrible, right? If you're going to pay lots of tax, unless you have a bunch of extra withholding. And we've seen a couple of times this has been done, where we've seen inflated income, but inflated withholding. I think that came from a theory that people had developed. Well, the IRS doesn't question you if you report excess income. That's true, right? You're not going to normally get a letter from the IRS saying, "Hey, you reported $120,000 worth of wages, and we only find $100,000 that was reported on W-2." You're not very often going to get an adjustment for that. But what they will not let you inflate without sending lots of correspondence is the amount of withholdings, right? There they would ask. And I think that that's kind of where the theory came from, though, was that we could do that and then inflate the withholdings and nothing would matter. Now, his medical expenses included $8 million of intangibles. Apparently, they were value he was providing to the doctors and hospitals, whatever, plus provider and workforce know-how. So he reported his total cost, right, involved not out of pocket. Out of pocket, he hadn't spent $8 million. He'd spent $1,700. So the court did a few hypotheticals looking through how he was doing stuff. So he said, so a $10 flu shot could end up translating to $30. That'd be $10 for the actual service, $10 for the value of the provider's know-how, and $10 for administration of the shot. Then he also valued the receipt. The receipt you get from the, let's say you get your vaccine at a pharmacy, right? Your flu shot there. So, which is where I got mine this past year, and they give you a receipt when you pay. We said that receipt itself was worth $10, right? It was worth $10 because that proved what he had paid. And so that allowed him to take a $10 deduction. So that was done. He also said there was a $10 for the value of the currency that was involved. So this $10 flu shot would end up being $50. But we're going to find out we're not done yet. Secondly, we looked at a cookie. So a $5 cookie becomes a $15 cookie. Again, $5 for the cookie. Amazingly, $5 for the goodwill that's being transferred, and you're not quite how that gets to that. And then $5 for the going concern for the baker. I guess his theory is he's providing that value to them, allowing them to stay in business and allowing them and providing them with extra goodwill because he's buying cookies. And then after those numbers are done, and you go through those, you're still going to find your way short of the numbers he reported. He inexplicably multiplied medical expenses by 54. Just flat out 54, what he had already done using this inflated way of compounding expenses. He then took those expenses times 54 to reach his final amount. And the court said this led to fantastical numbers. And also, it appears the court strongly suspected that he knew the result he wanted to get to. And he just came up with some theoretical method he claimed would get him there. And his 54 was simply a multiplier that came out of thin air. Right? Now, the government said, wait, under Title 26 United States Code, Section 2514, Special Plea and Fraud section, if you fraudulently attempt to get money from the U.S. government, you got a problem. They also asserted a counterclaim for 2020, trying to get tax from him. But the court is not dealing with that in today's case. Now, under Title 28, United States Code, Section 2514, a claim against the United States, because this is dealing with claims against the U.S., shall be forfeited in its entirety if the person corruptly practices or attempts to practice any fraud against U.S. in the claim proof, statement, establishment, or allowance. Court is finding this was fraud. It requires a specific finding of fraud or attempted fraud. And if that's found, the court has no option. Even if the court knows that a refund was, under traditional methods, that there was a refund due to this taxpayer, they can't award it. You totally forfeit any claim you've got against U.S. government when you engage in fraudulent procedure. It is known referred to as a silver bullet in Court of Federal Claim Tax refund suits. even attempted fraud that became very clear, even as badly a set of attempted frauds as this one, is sufficient for forfeiture. The court cannot ignore this. There's no discretion offered to the court. Once the fraud is found, you've lost your entire case. You're getting nothing, right? The government burden they had to prove by clear and convincing evidence that the claimant knew the claim was false and that the claimant intended to deceive the government. It can be shown by comparing documents and statements to well-known established facts. Mere negligence or discrepancies themselves are not fraud. As you might guess, in this case, the court's going to find that, that they knew it. They found the U.S. government convincingly met its burdens by clear and convincing evidence. The plaintiff's own testimony was crucial. They confirmed the actual W-2s that had been originally issued were correct, yet submitted tax returns that had entirely imaginary numbers. The direct contradiction established in the view of the court without a doubt the plaintiffs knew the numbers on the returns were false. Fabricated expenses, which they had some of that too, further supported this view. Fundamentally, at the end of the day, you got to say the court said, I don't believe you're this stupid, right? You had to know this didn't work. I'm not going to believe you are this dumb, is effectively what they're saying, right? That was kind of your position. So, bad news for the taxpayer. They found that they violated the, Section 2514 of Title 28. The claim was false and misleading and was intended to deceive the United States to get them to pay. It was a very poor attempt to deceive the United States. It was wildly unlikely to work. But the fact that, as I said, if it's attempted fraud's enough, right? They attempted to commit frauds against the IRS and the court. They had no reasonable explanation for discrepancies. Therefore, their claims are forfeited pursuant to Title 28, United States Code, Section 2514, and judgment was entered for the U.S. on their claim. Now, the reality is Statute 62514 is potent. Any claim tainted by fraud, even attempted, is subject to complete forfeiture. And, the burden is for the IRS to have clear and convincing evidence. If you have fanciful, unsupported valuations with knowledge of falsity and intent to deceive will lead to foreclosure. You need to adhere to actual figures and supportable positions. Now, hopefully, you're never involved in a case where somebody does something this off the wall. I think I would have had concerns trying to figure out how in the world these two had wages supposedly of this much money. You'd be looking at them overall and saying, how? Especially, how did his company? If you know anything about his company's operation, like, there's no way it paid him this much. So I hope we would notice that. But in any event, be aware of this. And it wouldn't necessarily have to be as bad as this. If the client is attempting to, get by with lies, at a certain point, that little white lie or fudging eventually gets big enough to trip it. Where does it do that? I don't know. But it's not a good idea to be caught in something like this. And again, this involves claims for refund. So again, with no claim, there's no problem here. If it's a deficiency issue, it's a different matter. It's still a problem. Defrauding the court's never a good thing, but it wouldn't be covered by this issue. Okay, let's talk about the tax collection, the statute of limitations, and tolling, because this is really important if you're in collections. This is a case, United States versus Timothy Ragen. It is case number 4:23CV306 from the United States District Court for the Southern District of Georgia, and the opinion was issued on April 30th of this year. Now, the United States sued the defendant, Timothy Ragen, to reduce unpaid federal income taxes for 7 years, 2004, 2006, 2007, 2010, 2011, 2012, and 2013, to judgment. Now, again, court notes it's a self-assessment system. The taxpayers filed returns but failed to pay the owed taxes. The IRS made the assessments, which include the primary tax, interest, and penalty. They had failure to pay, Late payment and accuracy penalties for 2011 was one of the years involved. The assessments were substantial. Hundreds of thousands of dollars in tax alone was unpaid and was assessed. The IRS issued notices of demand for payment. The taxpayer failed to pay. As of June 17, 2024, there was $1.28 million outstanding on the returns except for 2004. We'll talk about why 2004 is excluded, and accruing. Now, he admitted liability for unpaid taxes in his answer, but he didn't admit to the exact balances that were unpaid. So, we basically have here 1.28 million is the IRS alleged number. And yeah, that's where we sit at here. Actually, a bit more, because 2004 is going to discover there's a problem there. Now, you might think, well, this is kind of old, didn't the statute go? The IRS only has 10 years after assessment to collect the tax or get a judgment, right, against assets and things like that. Had they lost the 10 years, because many of these, you look at the case and its timeline, you're going, well, we're more than 10 years out, right? But different events will toll the statute, and Mr. Ragen had a lot of these. First, he filed a bankruptcy in July of 2008, and it was open, but eventually concluded without discharge. This is bad news. On December 15th of 2011. That will stop the statute, right? During a pendency of a bankruptcy. And the fact he didn't get discharges means that we just pick up and we just ignore that whole period of time in counting for our 10 years. Also, he submitted 2 offers in compromise. When you submit an offer in compromise, you're going to toll the statute as well. His first one was filed on November 19th of 2012. IRS rejected it in less than a month. Right? On December 10th of 2012, he then went and filed a new one on February 13th of 2013. IRS looked at this one a little bit longer, but essentially just over 2 months later, on April 19th of 2014, they rejected it. Finally, he made an installment agreement request. He filed that on August 31st of 2021, and that was ultimately rejected on March 11th of 2022. Now, he wasn't aware of how those impacted the statute, but he was trying to come to court to say the IRS is too late. And he did not respond to the government's summary judgment motion. And his counsel indicated no intent to respond or defend. I have a feeling by the time all the facts got in front of it, his counsel probably told him, you don't have a shot. You're going to lose all of these except 2004, right? If you want to keep paying me, that's great, but you're not going to pay me, right? Then we're out of here. The smart move for you to do is to just give up on this case. And so essentially they do that. But as I said, I suspect he didn't want to pay the attorney. So that was part of the reason why there was going to be no response. The government process to collect unpaid taxes. Taxes must be assessed within 3 years of the return filing, absent something tolling the statute. That's under 6501A. An assessment is a formal recording of tax liability. It is a government's determination when they do it. Now, all assessments have the legal presumption of correctness. Remember that? Burden of proof is on the taxpayer to show it's wrong. Typically, they're memorialized by a Form 4340, Certificate of Assessment, Payments, etc. There is notice and demand for payment within 60 days of assessment under 6303A. And if unpaid, the IRS can pursue a court proceeding under 6502A1 to reduce the assessment to judgment. Right? Now, if they're going to reduce assessment to judgment, then the first thing the IRS has to show is that there was a proper assessment made. Form 4340 will satisfy that requirement. Now we shift over to the taxpayer. You need to prove that the assessment was erroneous. Right? That's the burden. Now, timeliness is key because a suit to collect assessed taxes must be filed within 10 years of the assessment date. Now, if you just use that without any modification, you're going to find that virtually all of these would have been outside the 10-year realm for him. Certainly a large chunk of them would have. But the 10-year period can be suspended or told as the term goes, during any period the IRS is prohibited from collection activities. And in this case, we had tolling due to the bankruptcy. If you file bankruptcy in a Title 11 case, the IRS is blocked for the Title 11 case and 6 months thereafter by 6503H. You have tolled the statute. And an extra 6 months is because the IRS had to stop what they were doing. They got to get back up to speed. So you added 6 months to the statute by filing a bankruptcy. And since you didn't get a discharge, you've just extended the amount of time the IRS has to go after you by the time it was pending, and then by 6 months more. For office in compromise, it is suspended from the date of filing until it is terminated, withdrawn, or rejected, and then you add 30 days thereafter. And OICs often include a waiver of limitation period as well as part of the OIC. Installment agreements, when they're proposed, those also suspend the statute while the proposal is pending and 30 days after rejection of the installment agreement. So, as you can guess, there were a lot of extra days added in this case, the statute. These are huge reasons why you got to be very careful about throwing everything at the case. You got to be realistic. If you're trying for an offer in compromise that has no shot at being accepted, then all you're doing is adding time for the IRS to go to court or to collect otherwise. That's not a good move, right? Same thing about asking for installment agreements that you can't meet the clear requirements. And clearly a bankruptcy, because that's going to put a 6 month extra on the end, is a huge problem if you go into bankruptcy in a tax situation. You better realize what you're doing, right? The IRS, yes, it stops the IRS. The problem in a lot of cases is the clients all focus on the fact that doing each one of these did essentially prohibit the IRS from acting currently. So it got them by today's crisis. But they didn't pay attention to the fact that if, in fact, as is often the case, people that work collections will, often point out that in many cases, the only real option the taxpayer has is to try to wait out the 10 years and then hope they have nothing the IRS could get a judgment against. But if you're waiting out the 10 years, this is all going against that by extending the 10 years. And because this was a burden of proof argument, or burden of proof for a statute of limitations defense, the taxpayer is claiming the IRS is outside the statute. The burden is on the taxpayer to show that the filing came outside the statute period. Okay. Now, the court did calculate the total tolling period from all of these things: the bankruptcy, the offer in compromise request, the installment agreement. He extended the statute by 2,156 days. That's a long time. That's a lot of years that got added after we did this. It applied tolling to assessment dates to determine the timeliness of the suit filing, October 13th of 2023. The assessment of 2006, 7, 10, 11, 12, 13, and 14 were found to be timely. Now, 2004 is where things get interesting. 2004 assessment was untimely based on that straight up calculation. And so it's likely it could have been thrown out, but because the statute of limitation is an affirmative defense in the 11th Circuit, he did not raise this defense in his answer or his summary judgment response. So that's a problem, right? So he said he held that Mr. Ragen waived limitations defense. That waiver made the assessment recoverable despite otherwise being untimely. I mean, the court's saying it's likely, really likely it's untimely, but it's not relevant because you didn't show up and actually, you didn't show up and walk us through why it's outside the statute. That was your burden to meet. You didn't offer any evidence on the point. Assumption is it's timely, and tough luck. The government met its burdens with the Form 4340s, right? Every one of those, they showed the 4340 for the assessment. He failed to approve, now Mr. Ragen failed to prove the assessments themselves were erroneous. There was no opposition. He admitted to liability. Therefore, summary judgment was granted for the United States for the full amount owed plus additions and interest orders. Now, the key implication in practice, really, guys, you have to remember, warn clients. A lot of these clients who get behind paying people end up scrambling for anything they can do to just delay. The problem with delay for these options are you're stretching the amount of time the IRS has to wait. And one real problem we have in a case like that is the longer you wait, the more there is a possibility that this person will come into assets some way, shape, or form that would allow the service to collect. I mean, more time is usually in the service's best interest, right? To have more time before they have to go reduce to judgment. So it's a problem. Statute of limitations defenses is a waivable affirmative defense in the 11th Circuit. And if you're going to make that argument, you've got to proactively raise it, respond to court filings. Failure to do that, major problem. And, it's the effectiveness of government process. If the assessments are uncontested, if a taxpayer starts down this process and gives up or stops paying the attorney, and so essentially is going in unrepresented, yeah, it may not be a good result. It's going to be very tough to come by. Well, let's talk about moving expenses, right? You remember those, right? This is the civilian contractor problem. In the case of Tim and Wendy Kent versus Commissioner, this is docket number 14884-23. It was an oral opinion of the tax court from the bench. It was issued on March 20th of 2025. Finally got actually published here just recently. Now, the petitioners, this is Tim and Wendy, claimed moving expense deduction on their 2020 joint return, right? Now, the IRS issued a notice of deficiency disallowing the deduction. There is a proposed $3,951 deficiency. The petitioners did, Tim and Wendy petitioned the tax court asking for relief. Now, a few facts aren't disputed. In fact, a number of them in this case, major ones actually. They incurred moving expenses in 2020. The IRS agrees they did. Everybody states that's it, so that's there. The move was part of a permanent change of duty station for Ms. Kent's job with the United States Air Force. Now, Ms. Kent received official military orders, Department of Defense Form 1614, directing the move. However, neither Ms. Kent nor Mr. Kent was a member of the military in 2020. She was a civilian contractor for the Air Force. She was not, in essence, enlisted in part of the Air Force. She was an enlisted or off-enlisted person or officer of the U.S. Air Force. She was just a civilian. There are civilian employees of the Air Force. They exist. And the thing you got to remember is when things like this come up, most of the tax breaks given for military situations don't apply to civilian employees of the Department of Defense. And that's going to turn out to be her problem. Now, she said, wait, my move was initiated by, and they are the formal military orders for her work with the Air Force. She said, if you're ordered by the U.S. Air Force to move, that's when you get deductible expenses by the 2017 Tax Cuts and Jobs Act. And they said, look, the orders came from the military. The job relates to the military. We should be allowed to get the deduction. And I fully understand why they think that. But the problem is the law limits this, right? The question was, were moving expenses incurred by civilian contractors in 2020? Were they deductible under IRC Section 217? Remember that in 2017, the Tax Cuts and Jobs Act, for the most part, disallowed any moving expenses unless you met a narrow military exception. The taxpayer is challenging the IRS's disallowance by saying they meet that exception. Now, the court noted that as always, we presume the notice of deficiency is presumed correct. Because the taxpayer has the burden to prove error and entitlement to the deduction for Section 7491. And they also cite the old case of Welch versus Everling and Tax Court Rule 142A. They also give us the old line from Indopco, that deductions are a matter of legislative grace. The taxpayer must prove allowability under a specific statute, referencing Indopco and Supreme Court's New Colonial Ice Company case. Section 217, we passed the Tax Cuts and Jobs Act. Tax Cuts and Jobs Act suspended through the end of 2015. We're now in the middle of figuring out it's going to be suspended beyond that point, but suspended through the end of this year for sure, deductions for moving expenses under 217. So it was suspended for tax years beginning after December 31st, 2017 and before January 1st of 2026. Obviously, 2020 is within the suspension period. The question becomes, do they qualify for this narrow exception, right? Section 217K, added by the Tax Cuts and Jobs Act, says the suspension does not apply in the case of an individual whose subsection G applies. Always love these cross-sections. 217G, the exception applies only to a member of the Armed Forces of the United States on active duty who moves pursuant to a military order and incident to a permanent change of station. Here's the problem. So you must be a member of the armed forces, and now we're back to what does that mean? This time you're not going to find the definition in the section. You're going to find it in the title-wide definitions found in Internal Revenue Code section 7701A. 7701A15 defines what is the armed forces of the United States. And by definition includes regular and reserve components, commissioned officers, and personnel below the commission grade. We've had a number of rulings saying if you are a civilian, you're not entitled, even though you're working for the Department of Defense, even though you got military orders, you're not entitled to exclusion reserved solely for the military. As you might guess, that's the taxpayer's problem here, right? To apply the law to the undisputed facts, they didn't meet the criteria. Neither one of them was a member of the armed forces. Ms. Kent was a civilian contractor for the Air Force. She was not a member of the Air Force. Civilian contractors are not part of the armed forces, such that moving expenses would be deductible for them in 2020. The court specifically held that finding was there. They did not fall within a narrow exception. Neither one was a member of the Air Force. The court acknowledged the disappointment given all the pandemic military orders, but they said, we can't rewrite the law. Remember, if the law is clear, the court does not have discretion to go change it. They're not Congress. They're not allowed to rewrite the law. That's why it's always important to understand what the code says. Because while you may get the court to decide the IRS reg isn't quite proper, etc., if the code itself makes it clear your client's position is dead on arrival, you got to recognize that, the code. You can't try to argue things. And the other catch we discover in other cases is you can't try to argue, well, that couldn't have been what they meant. You go back to the Germain case, which I mentioned multiple times. Remember, from Germain, U.S. Supreme Court case was a bankruptcy case. But what they said there was, if the code itself, basically the U.S. code itself, the statute, has a single way of, you can read it, the text there, it really doesn't matter. Nothing else matters. As long as it's constitutional, we're good. And we're done. We have our answer. And it does not matter if Congress intended to do the exact opposite. What matters is what they wrote and they voted yes on, right? So taxpayers were not entitled to claim moving expense deduction, and decision was entered for the IRS sustaining this deficiency. Now, some key practice takeaways. Don't forget, hopefully you haven't forgotten, right? It's been enough years now. Moving expenses were largely unavailable in 2018 all the way through 2025. And I think it's very likely they'll be unavailable in the future. I haven't heard any rumblings yet that if we get a tax bill that somehow moving expenses are going to magically reappear. So far, that's not, absolutely nothing has been telling me that these are going to come back. Now remember, therefore, we're working under this 217G exception. and it is strictly available to members of the U.S. Armed Forces on active duty moving under specific military orders, right? So you got to meet that requirement. If you are a civilian employer or contractor, even when working for or moving under orders from military branch, you don't qualify for this exception. And that's come up in another context, which can be a little more confusing. There are individuals who work in both the reserves and the National Guard, both of which are reserve components of the military, who, despite the fact they are members of the reserve and members of the Guard, their main job is civilian with the organization. And that's true even though these people, which is where you'll get lots of confusion, are showing up for work every day in military uniforms, showing military rank. And I know about this mainly because my father, for many years, was one of those people, right? He was effectively a member of the military only for, 1 weekend a month and 2 weeks a year. Otherwise, he was a civilian employee and actually got, he got his paychecks. And when he retired, he got both a civil service retirement and a military retirement, right? The two were separate, even though all of it was done working for the Department of Defense. It didn't matter. So you got to advise clients accordingly when you are reviewing deduction eligibility for moves during the suspension period about what happened and what didn't. Now, this is a bench opinion. It cannot be relied upon as precedent in other cases, but it's likely a good way of showing an application of the statute. That is, unless somehow this judge got it wrong, likelihood is it's very likely going to be a result. So again, you can't cite as precedent because it's not really deciding anything new. It is, however, coming up with this, so it's something you'll consider. Now let's talk and end on, we're going to finally get additional guidance on the question of whether the 90-day deadline for filing your tax court petition, when the IRS has basically gone deficiency route, you've got a notice of deficiency, is that jurisdictional? Which means if you're day 91, it doesn't matter why. You're outside of the tax court can never hear your case. Or is it not? And this is the case of Naisha Oquendo versus Commissioner. This is oral arguments that were held this week before the Sixth Circuit Court of Appeals, case number 24-1205. And, those oral arguments were held on May 7th. And you can actually listen to them if you want. You put them in there. And actually, it's really interesting if you want to listen to them and go through them. So what's the facts of the underlying dispute? Because there's already a tax court order that said, I'm sorry, Naisha, but, you're late. So what were the underlying facts? The IRS issued a notice of deficiency to Naisha on May 30th, 2023. That determined a deficiency and penalties for the 2022 tax year. Now, under Code Section 6213A, generally it requires you to file your petition with the tax court 90 days after a notice of deficiency is mailed, if you are within the U.S. The 90-day deadline would have ended, and everybody agrees on this, on August 28th of 2023. However, Naisha did not electronically file her tax court petition until November 1st of 2023. Everybody agrees that's beyond the 90th day. We're outside the 90-day period. And IRS, of course, notices this, and they immediately file a motion to dismiss for lack of jurisdiction, saying that she's untimely. Right? She's outside the required filing period. The tax court has no authority to hear this challenge. Tax court agreed with the IRS, not surprisingly. They note, as you'll often see the tax court note, that they are a court of limited jurisdiction. They can only hear disputes authorized by Congress for them to hear. Now, jurisdiction for a deficiency case, because there are various types of cases the tax court can hear. This is a deficiency, right? She filed a return. IRS said, we believe your return's in error. We're assessing additional tax and penalties. Notice of deficiency is issued. When that came, you have to go essentially have a jurisdiction requires IRS showing that there was basically the IRS burden will be that they show there's a valid notice of deficiency. If no notice of deficiency was issued, then there's nothing yet to do. The IRS can't really go after anything until they issue one. And finally, and secondly, was the petition timely filed? Now, the tax court found the notice of deficiency was properly mailed, but they said the petition was outside the 90-day period. The tax court held specifically it has no authority to extend this 90-day period, repeating what it said many times. Now, the taxpayer is arguing for equitable tolling, and they're referencing a case we've discussed before, which held that there is, in essence, equitable tolling is available in a case like this. This is a Third Circuit case of Culp v. Commissioner. Now, at this point, there's not any real significant discussion about why Naisha thought she should get equitable relief. Because the real question now is not whether she gets equitable relief, but can she even argue for it, right? The IRS says, no, you can't. She's saying, yeah, but the Third Circuit said this in Culp, and they also argue at the same time, or counsel does, that an earlier Supreme Court decision that basically caused the Third Circuit to rule in Culp that there is, basically you could have this, we're talking about equitable tolling is an option here. You could, if you have a good enough excuse, we can make it work, that should apply. Tax court has said no. They've heard cases since then. And outside the Third Circuit, they will not consider equitable tolling. If you're in the Third Circuit, yeah, they will. Now, the tax court found that the Culp reliance was misplaced. The court said, well, this case is appealable to the Sixth Circuit, and the tax court position was that there was binding precedent already existing in the Sixth Circuit. Both in the case of the Patman and Young case, they held the timely filing deadline is jurisdictional. The tax court in Sanders v. Commissioner had already rejected Culp for any case that's appealable outside the Third Circuit. Now, under the Third Circuit, under the Golson rule, they will follow that. They will consider equitable relief. But that's the only circuit currently they will consider it in. So the tax court concluded that the petitioner was not entitled to equitable tolling in this case. Yeah, that was not a possibility, regardless of her reasons for asking for it. And so the tax court dismissed the petitioner's, dismissed the petitioner's petition. It said, we have no jurisdiction. We're not allowed to hear this case. Now, in her decision, the judge noted that there were alternative avenues available. She could administratively, continue talking to the IRS about this issue, or she could pay and sue for a refund. Now, the court recognized that might not be practical. But they said, those are options you have. Those are the options you have once you miss the 90-day period. You either try to get the IRS to reconsider, which is always a bit dangerous, you hope. But if you're outside the 90-day window, that's your only option. Oh, by the way, remember, don't just take IRS assurances that, oh, yeah, this will all get reversed before the 90th day. Because if it doesn't, you're out of luck. You want to make sure that if your client is going to dispute it, that they get ready with their petition. Once a notice of deficiency is issued, is somebody better be first considering, would you go to tax court if this, doesn't, if we can't resolve this in 90 days? And probably, if the answer is yes, get your legal counsel in play. And you might want to bring legal counsel in just to decide if you should consider taking this to court. But be ready to file a petition. Don't sit there, no matter what you're hearing, don't sit there and hope, because the problem is, if it falls through, you're the one that's got the problem. You had to get that signed. So until they either, get the problem solved or they withdraw the 90-day letter, you've got a problem, right? As long as that's out there, it's going to stop you from doing anything. The tax court will not listen to you, especially if this is jurisdictional. No question, they're just not going to listen to your case. Now, in the oral arguments this week before the Sixth Circuit, we had both the petitioner and the IRS put their cases before. Now, the question is this a jurisdictional? or claims processing deadline found at 6213. A jurisdictional one would end of talk. You're not day 91. The tax court has to have jurisdiction. If this has to be something that has to be met for jurisdiction to exist, and then it's absolute and we're done. Or is it merely a claims processing statute, right? To like get the claims in place. It is a strong suggestion, but it doesn't itself foreclose the ability to get relief for, equitable reasons. Now, of course, the taxpayer is arguing, her counsel argues that the deadline is not jurisdictional. It's just an ordinary run-of-the-mill claims processing rule subject to equitable tolling, just like the Beckler and the Culp cases, like the Beckler case. Saying, and Beckler was a case where the Supreme Court found that a similar limitation on the tax court, which I believe was in collection cases, that was merely a claims processing rule, and the deadline there was not absolute, that you could have equitable relief. Culp says, based on Beckler, we don't see where this is different. They did the same thing. Now, under the Supreme Court, Beckler requires a clear statement that a rule is jurisdictional, or the assumption is it's not. Taxpayer claims Section 6213A lacks a clear statement. The text only says what the taxpayer may do. It never says that the court shall do these things. The taxpayer may do these things, but it doesn't say and restrict the court. They're saying there is no explicit, because the IRS is going to try to argue it's implicit. They're going to say, no. Based on our reading of Beckler, it needs to be explicit and clear that this is a jurisdictional provision and not one that's merely for claims processing. So, taxpayers' counsel says, since it's not jurisdictional, it's presumptive subject to equitable tolling, like the Irwin case. And nothing in 6213A per the taxpayer counsel, rebuts this. And also says, look, the holdings they're giving are holdings you, Sixth Circuit, had issued prior to Beckler. So Beckler undermines all those prior holdings. You got to kind of do this. Post-Beckler, after Beckler, has found 6213A text even weaker for jurisdiction than Beckler was. The statute in Beckler. So therefore, essentially, if Beckler allows equitable tolling for their claim, then claims under 6213A have to have the same rights. And they also said, remember, the Supreme Court was asked by the IRS to, take on the Culp case, and they denied cert. And the taxpayer is saying, we understand that's not absolutely binding, but we believe it is very significant. Certainly the court did not wildly disagree or wildly believe, that this was a wild misreading of the Beckler decision. So the taxpayer suggests the Sixth Circuit should decide equitable tolling's availability, the legal question. Now, this is a problem. They discovered that, because they never got to whether equitable tolling was something you could do, they said, Sixth Circuit, really, equitable tolling, whether equitable tolling is available here is a legal issue. And theoretically, the question of whether the statute's jurisdictional is separate from whether you can get equitable tolling. They're saying, but really, they're very closely tied. And if you remand to the tax court to decide if equitable tolling is available, the court is likely, they believe, to come back and rule, because they've been very much hard line on this. No. Even though this might not be a jurisdictional provision, equitable tolling is not available in this case. They said, rather than have it go back down and then it have to come back up and you guys have to overrule it, then go back, the smart thing to do in this case is to settle both issues and keep it from bouncing. And the other thing, because I was going to argue this, they said Section 6512 does not bar refund litigation if the petition is on filing, is untimely, if equitable tolling is denied. IRS is going to argue that one of the problems you're going to have here is, and we'll discuss this more on the IRS side, but 6213 says once there is a final tax court decision on the notice of deficiency, you cannot then pay the tax, go to the district court and sue for a refund. That makes finality. You can't go both routes. So they're saying, the IRS is going to argue that you've taken it too far. So if in fact it's subject to equitable tolling, then essentially, if the court finds that, so the court would need to consider it and rule on it in any case somebody was late. And once they do that, you would never be able to go to a refund. So if you mistakenly file in tax court outside the 90-day period, right now you could just go back and, assuming your statute's still open for a claim for refund, you could obviously pay the tax and sue for a refund. But now you just got to pay the tax. They're saying that'll be the IRS position. The taxpayer here says, no, it says if the petition was not filed within the time prescribed, they're saying that would be the effective ruling, that it was not filed within the time prescribed. And while they agree the IRS doesn't agree with that reading, the taxpayer is saying all you need to worry about, Sixth Circuit, is that there is a reading. You don't need to decide that right now. What about the IRS? The commissioner says no magic words are needed for jurisdiction, quoting the Arbaugh case. You consider the text, the context, and the history. They said 6213A has unique context in the history. They argue the jurisdictional grant is in the first sentence of 6213A is linked to the cause of action. They claim that Culp in the Third Circuit and Culp glanced over this. They cited the Ninth Circuit organic cannabis, which followed both Arbaugh and Beckler, holding the deadline jurisdictional based on the context, text, context, and history. Now, the IRS also says there is going to be a harsh consequence of Section 7459D if that deadline is not jurisdictional. A dismissal for non-jurisdictional timeliness is treated as a decision on the merits, which precludes other challenges for that tax year. It creates, they claim, a trap for the unwary. If you go to tax court late, right, and of course, then you're going to try to preserve it, and so the court rules against you, you've lost any ability to challenge the tax. Right? And they noted the Culp taxpayers filed protective refund suits as evidence that they considered this problem might exist. Now, and even if equitable tolling is available, most taxpayers don't qualify. This is it, in essence. And that's true. Equitable tolling is not, that deadline is presumed to apply in the vast majority of cases. And the IRS took a look at situations where there is equitable tolling is allowed for various filings with the court. And they found an insanely small number of cases where equitable tolling was raised. Did the taxpayers prevail? And they suspect it'll be at least that bad here with notices of deficiency, right? So, the tax court is laying collection by evading the tolling in the Third Circuit cases. You still can't go to, tax court's going to have to delay and wait and slow up collection. And it's just going to slow the process and put the people at risk. They're saying that if you affirming jurisdictional dismissal, that's less harmful to a taxpayer than reversing and then having a denial of tolling, which leads to preclusion under 7459D. So they asked the court to affirm. Now, we don't have an answer yet. We did have, though, the judge's question. They said, look, given the circuit split post-Beckler, what about that? What's the impact of that? They did ask for the precise location of where the jurisdictional grant was. They wanted to see what each side said about that. What language is jurisdictional? What would it take post-Beckler to have jurisdictional language? After taking Beckler into account, what's necessary to find that there's jurisdictional language? They also discussed, why they should decide, the question is really, do we decide equitable tolling versus remanding for that? Pro and con. They had the parties discuss the impact of the denial by the Supreme Court of certiorari in the Culp case. Is that important? Is it irrelevant? Is there a harsh consequence under 7459D? If equitable tolling is available, are we going to shut down people and get rid of their only option because they're going to go through and erroneously file in the tax court? Do they really have a refund suit still in that case? In either case, and the intertwined nature of the jurisdiction and tolling, what cases could you have a jurisdictional issue but not be allowed for the equitable tolling, and talk about that. The discussions of the judges had some, complexity and significant practical stakes. And as far as this goes, for the Sixth Circuit, that decision is critical. If we get another court going the way of the Third Circuit, you begin to wonder how the winds are going to blow. And more importantly, is the U.S. Supreme Court now going to pick up the issue? How is it going to run? Again, if enough circuits rule in favor of it being let's say, non-jurisdictional, so that you could have equitable tolling, eventually the other circuits will probably just give up. They hadn't decided, the other circuits will follow, and any circuit that has decided would probably reverse. And usually the tax court looks for at least 3 circuits to have overturned it before they will consider whether they'll reverse a position that they've taken in the past. Now, this decision will clarify the 90-day deadline for those in the Sixth Circuit. That's so much we know is clear. Remember, under Golson, the tax court is going to be bound to follow whatever this court rules unless the Supreme Court takes on the matter and overturns it, right? Basically overrules it. That's here. It's going to also determine the potential or lack of potential for equitable relief for missed deadlines, and it would impact advice to clients regarding missed tax court deadlines and availability of other forums. Is it really true that, at this point you'd have to pay the tax and sue for a refund, or is there a chance with a late tax court petition to still qualify? It's going to be important, especially if you're involved in, collections and those sorts of issues. Yeah, you keep abreast of this, right? You know what's there. Keep your eyes open to see if this is there. Now, ultimately, this is more of an issue for attorneys, because attorneys normally are the ones that would take you to tax court. In that case, although, yes, I understand, yes, you as a non-attorney can take the tax court exam. I think they just announced the next one coming up here this week. And it won't be this week, but it's coming up here down the line a little shortly. Yeah, they're going to hold one again. Wow, excitement for that. By the way, the passing rate for non-attorneys in the tax court exam, not really very good. Just going to say the vast majority of people that take it fail it. So you understand how that goes. So it's going to generally be attorneys that are involved in this, who are going to be looking at these deadlines or looking at the issue of what this does and would we have equitable relief. I think one of the problems, too, is if we do find equitable relief is available, then what's going to be interesting is seeing what the courts tend to usually allow as equitable relief and what the courts say, nope, that doesn't work. This has been the Current Federal Tax Developments for the week of May the 12th, 2025. Current Federal Tax Developments are brought to you by your state society of CPAs. Ed Zollers coming again from Phoenix here, nice and warm Phoenix. We're heading for triple digits over the weekend this week, so we'll be there. I guess we start dropping on Tuesday. So we're going to have some nice triple digits all the way up to 106 over the weekend that I'm looking at right now, because I obviously don't record this on Monday morning. I record it earlier than that. So we'll see what goes on in that realm. As I tell you every week, you can contact me, edzollers@currentfederaltaxdevelopments.com, for email. You also can find me on the New Jersey and Arizona Connect sites, as well as Connect sites for Minnesota, Illinois, Washington, and Idaho. So if you have questions there, post them there. And if I see something I think I can respond to, I may pick up your line and respond back with it. Otherwise, we got yet another week going. So remember, not-for-profit first deadline comes up this week for calendar year, so keep that in mind. Otherwise, we will see you next week with more current federal tax developments.